Hi, welcome back to my channel. Today's presentation is about open access and author rights, and I'm going to help you to answer some questions of how can I share my data set, how can I share my publication, even if it is not published in an open access format. Now, the presentation is a part of a playlist on open science. Previously, I talked about open science, open access publishing, open data, and open peer review. And it's a follow-up of those presentations, so don't hesitate to watch them to better understand today's presentation, because I will build on them. Now, what is the objective of today's presentation is to help you to learn about author rights and permissions to share published articles, and to learn about how to license and share research data in general. When we talk about today's presentation, I'm going to talk about the stakeholders involved in the industry, the legal concept that you need to know about, what are the different publisher agreements, and what are your author rights before having some takeaway messages. So let's start with an introduction. When we talk about open access, it has a lot of advantages, among them the increase of your visibility, the valorization of your work, the increase of number of citation, faster communication between peers, and the development of expert networks in your community, whether it's scientific or industrial, and for sure complying with funder requirements who are more and more in standardized countries requiring to have open access publishing and data sets. And for sure, on the long term, it's the best way to store the data without having the burden of hosting your own website and promoting your own list of publication. However, when we talk about open access publishing, there is a lot of legal aspects and a lot of confusion around it, especially that we have two important points that we need to focus on. From one side, you as the author, once you publish your work, it's available online. Everybody can read it. You're very worried about your intellectual property and that people will reuse your work without citing you. So here I'm going to talk about this aspect and give you some answers. And the other problem is that if you are not publishing in open access, but you are forced to make your data available in open access format, you will be most probably violating your contract with your publisher. In this case, what should I do? The tension between the public funding agencies and the private publishers, in this presentation I'm going to help you to understand and solve this problem. Now, before starting, you need to understand a very important concept in this domain of rights, which is related to the intellectual property. Intellectual property is the strict respect for the intellectual property rights of all those involved in the production and the publishing chain of an article and data sets. So we need to be aware that it's not only a relation between you and your university, or you and your promoter, or the institution you work at and the funding agency. It's also a relation between the publisher. So this means that there's a complexity, and each of those entities, whether the funder, whether the research institution, or the author, or the publisher, they are not having the same interest. And here comes the conflict, and therefore we need to resolve it. And in general, we are talking here about different stakeholders, and we are talking here about different types of contracts that require a publisher permission. And therefore, before publishing and when we start deposing or setting our data set in a repository or publishing it in a journal, we need to consult the Sherpa Romeo. What is the Sherpa Romeo? Simply, it's an online resource that aggregates and analyzes publishers' open access policies from around the world and provides summaries of publishers' copyright and open access archiving policies on a journal by journal basis. So I advise you to access this database of Sherpa Romeo so that any journal you are thinking to publish your work at, you can directly check, and then you will understand exactly what will be your rights. What can you publish? Can you publish the manuscript in its final format or not? Can you have a preprint? Can you have a post-print publishing? The data set, can it be shared fully or partially, and so on and so on. Let's move now to the stakeholders involved in this process. Like I told you previously, when you are publishing a work, you think that it is maybe one or two stakeholders. In reality, not. There is a lot of stakeholders involved in this publishing industry. We have the university or the research centers. We have the users, the reproducers of your work, anybody who is interested to reproduce your work. We have the funding agencies, we have the publishers, we have the people who read the work, and we have the authors who create the work itself. Between all those, there's different tensions, and therefore I need to go through a very thin line to make sure that I'm not going to violate any of those rights. Now let's go through some important legal concepts that could be considered as a basis for our next step to understand your author rights. So what are the legal aspects of data in general? When we look at the legal aspects of data, we look at different data types and regulation. If we say personal data, it's the GDPR. If we're talking about publication, it's copyright, it's the intellectual property, it's the licensing, it's the Creative Commons, and so on and so on. If we are talking about industrial or economical information or patents or industrial secrets, then we are talking about confidentiality agreement. Then we are talking about non-disclosure agreement. So it's very important to understand these concepts, and in these following slides I'm going to explain more into detail. Intellectual property, like I explained earlier, is not a concept that is only related to the copyright, and it's not only related to publication. It's also related to patent, trademarks, trade secrets, layout design, and industrial design. But it's very important to understand that intellectual property needs to be either protected or made available without violating the author rights. So in this sense, it's very important to understand that we use the copyright as an agreement to protect the intellectual property, even if you decide to make the work in open access format. So actually making the work in open access format or not in an open access format does not have any implication on the intellectual property, because by default, in any case, your work must be protected, must be cited, must be recognized. It is your choice who make it publicly available or not. Now, when we talk about legislation, the legislation defines the scope of intellectual property rights to whom and what entity can benefit from it. So Copyright Act simply talks about a person who has created a literary or artistic work shall have copyright therein. Intellectual property legislation is contractual, you must sign a contract. And contracts and permissions define how the intellectual property can be reused. So here comes the importance of intellectual property. Also a very important concept when we talk about intellectual property, when many people or when people decide to publish their work or make it publicly available, even if it's a figure, it's a graph, it's an artistic work, it's a publication, without going through an agreement with a specific publishing house, they can have a license associated with their work. And this license will protect them. And as I previously mentioned in the video on Creative Commons, the Creative Commons helps you to have a license that protects your work without having a contract with a publisher. And here all articles published by academic journals or data depositories, even if they are in open access format, they have a Creative Commons attribution, which is an international licensing system, and this permits anybody to copy, redistribute, remix, transmit, and adapt the work provided the original work and source appropriately and cite the authors or the creators of this content. If you want to know more, just watch the video. Now, when we talk about the concepts related to legal rights, also we must take into account data ownerships. Never underestimate the importance of this aspect. By default, your university owns the intellectual property rights related to your PhD, including the data generated during the research activities that took place. And if your PhD is not funded by your university and is funded by a public institution, then this public institution or private institution that funded their work, they own the data. So you should always be aware, always understand that the data that you are generating, if you are funded, not self-funded, then the data is owned by the funder. So this is very important, and the same applies to projects funded by public institutions. So it's very important to be aware about it, because if you are going to publish a data set, for example, in a journal, first question you will be asked, who is the owner of this data? And we find in 80% of the cases, authors publishing a data set and they are not aware about the ownership, and they think they are the owner of the intellectual property, which is not true. It is always the funder, regardless if it's the university or a public or a private institution. Another important concept that you need to be aware about in the European context, member states must ensure that publications resulting from publicly funded research are freely accessible as soon as possible and preferably immediately, and in any case no later than 6 months after the date of publication and no later than 12 months for publication in the fields of social sciences and humanities. So also this is a very important rule. If you are working in the European space, the 27 member states or the 28 member states, you need to take into account that the rules in Europe mandate that any work publicly funded must be published in open access, whether it's a data set or it's a publication. So if you are going to publish with a editor or with a journal publisher who has a subscription-based data sharing system, you need to find a solution to bypass this conflict, because from one side your funder is telling you to make it open access and your publisher is making it not in open access. And when you publish it, you will sign a contract. And here comes the conflict. How can I bypass this problem? Now, also important obligation regarding content sharing in the EU Copyright Act. You have to deposit publication and data in public and open repository, and the European Union has an open public repository. So if you are in any European member state and in the country where you work nationally there is no public repository, you can refer to the European Public Repository. Any publication resulting from research work carried out by people benefiting from public funding must be made available. The author of scientific articles must make their work publicly available, and any work resulting from research financed for at least by 50%. So from 50% or more, you must make this work publicly available, unless it is 49% publicly funded or less. In this case only, then there is a right to not make this data publicly available. Also, another important aspect that you should take into account when we talk about regulation, the GDPR. There is a full presentation about it. If you are interested, it will be a follow-up, so don't hesitate to watch it. And it's talking about the General Data Protection Regulation, which is a set of regulation protecting the privacy of humans, and it addresses the collection, processing, storage, and transfer of personal data inside and outside the European Union, informing subjects of the use of their data, ask for consent and allowing them to withdraw their consent at any time, and protecting the data from transferring, leaking, and publishing. And for sure, it is mandating the anonymization or pseudo-anonymization of the essential data. So all these aspects or concepts are taken into account, and they are important to take in consideration. In summary, like I told you, in this aspect, you need to be aware about the type of information that you are going to share, the data, publication, figure, data set, atlas, whatever, reports, and so on. And you need to know what are the associated regulations. And you need to know that once you have a copyright, if you have an agreement between a third party, between you and your entity, whether you are representing a research university, and there's a funder, and there's a publisher, directly there must be a contract, and this contract can have some conflicting issues. Now finally, I can talk about the different publisher agreements, and I can take you to the more detailed information that helps you to understand what happens when we publish. Well, when we publish, we have mainly 3 types of agreement. First of all, we have to publish in a fully open access journal. This can happen. Take care, most probably you will have to pay the article processing fees, which are very expensive. Option 2, you have to publish in a subscription journal through a transformative arrangement that is available to you via your organization. So here you have a publishing contract, and here comes the binding condition. I have a contract, which means I cannot share the data easily. And number 3, you publish in a subscription journal and take responsibility for making the author accepted manuscript freely available from public depository. And here falls 95% of researchers, or even 99% of researchers in the European Union. Most of them, they publish into subscription journals because they are prestigious, because they don't have money for open access processing charge or the article processing charges. But because they signed a contract of publishing, they cannot share it. So in the same time, they have a conflict with the EU Open Access Funding Act, so they must make this document available. So between both 2 solutions, they try to find a compromise, and that's what I'm going to talk about. But when we talk about a published contract, you must respect it. You sign a publishing contract, what is it? It's a contract under which an author authorizes a third party, which is the publisher, to reproduce and distribute the reproduction of this work. So here comes the conflict that many people forget about. When you sign a copyright agreement with your publisher, it is now the publisher who should promote your work. And how they promote it? They promote it on their website through a subscription fee. So you cannot anymore take this work and make it available online easily, because you already gave the rights for the publisher to do it for you. Now, if you are in this situation, what should you do? Here comes the importance of author rights, and here comes the importance of having different exits for this problem. Well, we all know the European Union is forcing you to publish the work if it's published funded work or in your national country. Now, how can we retain the right to share the manuscripts? This is a very important question. Well, as an author, you have the right to publish the post-print version or the after peer review post-print. Either the pre-print or the post-print version can be published, but not in the publisher's layout. Not in the publisher's layout. If you see here, this is a layout of a publisher, Elsevier, the journal called Sustainable Cities and Society. I cannot share my publication because the content is mine, but the layout now and the copyright agreement made this paper belonging to the publisher. How can I get out of this problem? I can share a post-print by copying this content in a Word file and not using this layout, using my own layout and making it available. This is how I can get off this conflict. And I have the right to do that as long as the work is publicly funded. So the publisher has the right to make the manuscript not freely accepted because they are spending and investing in layouting the work, they are managing the peer review process, they are hosting the paper online, and also the publisher can decide themselves through an additional agreement if they want to make the work freely accessible or not. But by default, if you signed a publishing contract, you cannot make the work available in its published format provided by the publisher. Now let me take you again to the EU regulation that says that the author must guarantee author control over the integrity of their work and the right of the properly recognition and citation of the work. Making your work published does not mean that anybody can violate this right. So the important concept here is that anybody must respect the intellectual property rights of you as an author when you share your data in open access format, and the signature of a user license allowing to read, download, copyright, print and distribute the articles still protects your work, so don't worry. So once you make your work open access, it is protected and people must cite it. So this is my key message. Now let me take you to a case study or an example that happens with me often. I have an account on ResearchGate, and sometimes some authors, they have published their work in a subscription-based journal. And I want to read it. So I send them a personal message and I ask them, can you share with me please your publication? It's a personal message. Surprisingly, those authors, they reply and tell me, sorry, we don't have the permission to share the full text. Yes, you don't have the permission to share this full text, but publicly, but not in a private message. And here comes the mistake, and here what I try to explain. You need to follow some training. I asked them to tell them, you have to know that you are allowed to share your copy in a personal message. There is no problem with that because it's a personal communication. But you are not allowed to share it publicly through ResearchGate. And this is something I did not ask for. I just send a personal message. So you as the author, you need to know in this situation what to do. If somebody asks you for your work, first of all, you as the author, you have the right to share the work on internal institution repositories. And you can share it in a post-print format, not using the template or the layout formatting of the publisher. This is first of your rights that you can do. Number two, you can share the accepted manuscript earlier version, also not using the publisher's template. So you can have a pre-print format. This is second right. So I can have a post-print, I can have a pre-print. I can put it on a internal repository. I can even put it on a public repository, as long as I am not using the publisher's layout. Number three, and the last option that I have as an author, that I can share my publication, but in this case, the publisher version, privately in a private message. So I can share it via email, I can share it via LinkedIn, I can share it via ResearchGate, academia, whatever platform you are using, but a private message from an individual to an individual, based on a request for sure. So these are your rights as an author. Never underestimate them. Exercise these rights, because if you are not going to do that, you will lose what I was talking about at the beginning. Your visibility, your citation, the valorization of your work. You'll be totally alienated because nobody can access. Believe me, many people in the world today, even in standardized countries, they cannot access many subscription-based journals. So don't kill this way of communication, because you have the right to share the data as long as you want to do it. Now, on the other side, if you are afraid that the open access data will make the data available for anybody who do not deserve it, don't worry at all. The reader who will read your work in open access format, they have to indicate in any quotation the source of the work and the name of the authors. They cannot modify your work, they cannot transform it, they cannot adopt it in their work without explicit authorization from the author. They cannot use the work for commercial purposes. They cannot use it in any such a way that will harm the exploitation of the work. And don't forget today, if you are filing an industrial patent, if you are publishing a new journal paper, there is very powerful plagiarism software that will read all available data online. And if they find your work not cited in any research proposal, they will directly consider it as a plagiarism. So don't be afraid at all that your work will be always protected, even if you publish it in open access. And this is one of the main messages of today's presentation. Allow me to end up today's presentation. Some takeaway message before we leave. Well, what is simply the rights of an author today? The rights of an author simply that your university owns the data and the intellectual property of your work and your PhD, and even the funder owns the data set that you're generating. But never forget that you can always reproduce your own work. You can copy the work that is published with a subscription-based journal, and you can put it into a journal. You can put it in a Word file or LaTeX and share it yourself on a public or personal repository. You need to know that. And also don't forget that if you want to get out of all this hassle, publish from the beginning in an open access format. Just you have to pay the charging the article processing fees. So this is the challenge. Be always aware about your rights as an author. Open access does not mean losing the intellectual property of your work. The Creative Commons licenses protect your work fully. Don't be afraid. Publish in open access. Any public funded research or data must be made available via public repositories. So you need to seek these public repositories. You have to know what are the rules in your region, in your country, and you have to seek those public repositories so that you can always share your data and make it accessible online. Publishing contracts do not retain you from sharing your data. So even if you signed a publishing contract with a publisher, this does not mean that you have to invest and make some more effort to at least make your data available. And in the worst case, if you are so afraid or you are panicking that you will violate these contract conditions, at least when somebody asks you through social media or professional media to share your work or via email, be generous and just send them the PDF as it is and don't be afraid. And for sure, make sure to share your paper in the right format and in the right platform, and from the beginning, if possible, publish in open access. Voila, this is the end of today's presentation. Don't hesitate to share it. Don't hesitate to watch previous videos. There are coming videos about the GDPR, about how to publish in data in brief, what are the Creative Commons. So don't hesitate to comment on today's presentation, ask questions. If you find something that needs to be improved, complemented, don't hesitate. By that, I end up today's presentation that was about open access and author rights. Good luck with your publication of your publication and your dataset. Thank you.